Hi everyone, and welcome back to Texas Business Court Insider. I'm Andrew Price. We have a very special episode for you today. With me is my partner, Susana Medeiros. Susana focuses her practice on helping our clients manage data risk from a litigation, e-discovery, and data law perspective. And she has spent a lot of time covering significant developments across the country at the intersection of artificial intelligence and litigation privilege, a really hot issue. And recently, the Texas Business Court weighed in on these issues, so we wanted to have Susana on to discuss this development. Susana, welcome to Texas Business Court Insider.
Andrew, thanks for having me.
Well, let's jump right in. About a month ago, Susana, the 11th Division of the Texas Business Court issued an order in the Tate Group Automotive case, finding that a chat log between a litigant and a generative AI tool was protected by the work product privilege. This is the first Texas Business Court decision to substantively address whether AI chat logs can be privileged. And it follows a growing trend of courts determining that they can be privileged under certain circumstances. So let's get into the details. Tell us what this case was all about, Susana.
Well, the Tate Group litigation arises from a contract dispute. Tate Group Automotive claimed that its would-be business partners reneged on an agreement to finance Tate Group's acquisition of several car dealerships. The defendants counterclaimed and joined the group's individual members, including Chris Tate, as third-party defendants. During discovery, it came to light that Chris Tate had been feeding responsive business documents produced in litigation into a generative AI tool. The defendants requested the related chat logs. Tate Group produced some, but withheld others on the basis of work product privilege, and that set the stage for this dispute.
Well, so Susana, what were the defendants trying to argue with regard to why privilege didn't attach?
Sure, the defendants made two main arguments. First, they said work product privilege could not apply because Chris Tate is not a lawyer. Second, they argued that even if it could apply, Tate waived any privilege by communicating with a third party, namely the developer of the AI platform. To support that position, they cited United States v. Hepner, a federal case out of the Southern District of New York, where the court rejected a non-lawyer criminal defendant's attempt to claim work product protection over those AI chat logs.
Well, and so obviously Tate Group was taking the other side of the argument. What was their position?
Yeah, that's exactly right, Andrew. So Tate Group countered, citing a different line of federal authority. They cited Warner v. Gilbarco out of the Eastern District of Michigan, where the court extended work product protections to a pro se plaintiff's GenAI prompts and outputs under Federal Rule of Civil Procedure 26b-3. And on the waiver question, Tate argued, consistent with that Warner case, that the AI platform is not really a third party in the traditional sense. It is a tool, not a lawyer or a person. And because the disclosure was to a tool, not to an adversary, there was no waiver.
So with both of these positions kind of teed up, how did the Texas Business Court analyze things?
Yeah, I think that's where the jurisdictional analysis here becomes critical, especially since both parties were citing federal precedent. So the Texas Business Court first had to determine whether work product protection could even apply to these chat logs under Texas law. The court determined that the answer was yes. In the court's view, the defendant's citation of Hepner was not applicable because, of course, the federal rule was not at issue here. The Texas rule for work product was.
Right, and the key distinction is textual and lies in the Texas Rules of Civil Procedure, specifically Rule 192.5A1 protects materials prepared in anticipation of litigation by or for a party or a party's representatives. And that language is broader than what some federal courts have applied. And the business court zeroed in on the fact that Chris Tate, this individual, was a party to the case. And he was the one using the AI tool such that the materials were made by a party in anticipation of litigation. And under the Texas rule, that is sufficient to trigger work product protection. And that was true even though Tate himself was not a lawyer.
I also think it's worth noting that even under the federal civil rules, courts have been reaching similar conclusions. So in Morgan v. V2X, the court found that Federal Rule 26b3 protects a party's own mental impressions, not just those of counsel. And so although the Morgan case involved a pro se litigant acting as both party and counsel and did not necessarily need to reach the question of whether a party's own mental impressions were protected, the Morgan court specifically distinguished that Hepner case as a criminal proceeding and relied on the text of the federal civil rules to conclude that a party's work product, including their use of GenAI, is protected. So I think what we're seeing here is a convergence on the civil side, whether it's within state or federal courts, that the work product doctrine can cover a party's AI interactions.
And that really brings us to the second level question that got addressed in Tate Group, and the one that I think generally comes to mind when people are thinking about use of these generative AI tools, and that is, does communicating with an AI tool waive privilege? Susana, what did the court say about that?
The court found that the use of an AI tool in this case did not waive privilege. And it cited favorably to both Warner and Morgan, which we just talked about. And really, the Texas Business Court focused on whether the inputs and materials disclosed to the AI tool could reasonably be obtained by an adversary. As the Morgan court put it, even if disclosure to an AI platform is technically a disclosure to a third party, the third party being the AI platform developer themselves, that developer is not the party's adversary. And given how AI platforms work, it's highly unlikely the information would fall into the hands of an adversary by virtue of inputting that information into one of these AI tools. The Texas Business Court adopted that reasoning from Morgan and found that here Tate's GenAI use did not constitute waiver.
And I think framing it as Tate's AI use under these facts is important and a really important caveat to the court's ruling. The court certainly did not give a blanket pass here. The court made clear that work product protections did not extend to the underlying discovery materials that Tate had submitted into the AI tool, including documents that had been designated as confidential under the party's protective order. So the privilege log covered the chat log itself, the prompts used, the analysis and the outputs generated by the tool, but not the source documents that Tate had fed into it.
That's exactly right. I think that is a crucial distinction and also a very pragmatic one to distinguish between Tate's own interactions with the AI tool as opposed to materials produced in discovery that would be confidential under the party's protective order. The court went further still. It encouraged the parties to negotiate amendments to their protective order to specifically address the disclosure of confidential information in the context of GenAI tools. The court even directed the parties to look at the Morgan decision, which discusses concerns about feeding confidential information produced by the parties into AI tools that lack appropriate protections. I think we're all well aware that certain AI tools may even train on data inputs. And so ensuring appropriate protections is paramount. So I think the takeaway here is that even when privilege is not waived, there can still be real problems with how GenAI tools are being used in litigation.
Totally agree. And that kind of brings us to the practical implications of this opinion. And I think there are three big ones for litigants and attorneys to think about. The first is that jurisdiction matters, potentially a lot. And not all privilege laws are the same, and the formulation of the work product doctrine varies across federal and state rules and between civil and criminal proceedings. You could have nearly identical facts and reach different outcomes depending on which court is analyzing the issue. And that creates a real challenge for in-house lawyers and litigants and their counsel, because you may not always know which jurisdiction you will end up in when you are preparing pre-litigation work product, for example. And if you're using those tools during that phase of the case, you need to be thinking about the most restrictive standard that could end up applying, not the most favorable one.
The second takeaway we should consider is on that waiver question, where we're really seeing a trend among courts. The Morgan and Warner decisions, which come from federal civil proceedings, and now the Tate Group order from the Texas Business Court, all agree that disclosure to an AI platform is not an automatic waiver of privilege. Parties are going to start building on this line of authority to argue in other jurisdictions that their AI chat logs and interactions remain protected. Now, I wouldn't say this is settled law by any means, but it appears that the weight of authority is moving in this direction.
Agree. And the third takeaway, I would say, is specific mainly to Texas practitioners. As we said at the top, this is the first time the Texas Business Court has pulled back the curtain on how it's going to work through these GenAI privilege issues. And for anyone who may be subject to Texas rules, particularly the Texas Business Court, this order is a roadmap. It tells you how the court thinks about the scope of work product protection, how it evaluates waiver, and what it expects the parties to do with respect to protective orders and confidential information. So, Susana, you specialize in this area. How are you advising your clients right now in light of not only the Tate Group Automotive case, but this entire developing body of case law? If you had to distill this down to one or two pieces of advice for attorneys and litigants, what would it be?
I'm telling my clients to be intentional and be prepared. If you or your clients are using GenAI tools in connection with litigation, you need to think carefully about what are you feeding into those tools and whether the jurisdiction you're in or anticipate potentially being in protects party work product. You also need to consider whether the AI tools you or your employees are using have adequate protections and if they train on your data. And then finally, once litigation commences, you need to consider how your protective orders actually address the use of AI by both parties. The law is certainly developing quickly in this area, and I think the Tate Group order gives us a useful framework, but it's not going to be the last word on this issue. And Andrew, I know you said only one piece of advice, but I'll just add one more, which is that you should make sure to document your process. Courts are going to want to understand how and why AI tools were used. The Tate Group order also noted that even where privilege applies, courts may still require litigants to disclose which AI platform was used, the existence of any AI chat interactions, and what documents were submitted to the AI platform, particularly if these were documents, confidential documents, subject to the party's protective order. I think transparency about the process, even while protecting the substance of these interactions, is going to be really key going forward.
That's great advice, Susana. Thanks so much. And thank you for walking through this with me. This is a space that's evolving rapidly, and we will continue to monitor developments as more courts weigh in. Everybody, thanks for joining us on this episode of Texas Business Court Insider. Make sure you check out our hub for our latest analysis and updates, and don't forget to hit like and subscribe so you receive notice of our next video. We'll see you next time.